IRCC to invest $5 billion in programming, new changes to the Post-Grad work permit eligibility, a new pilot program for Francophones, and a number of important cases, including on artificial transactions in this edition of ImmPulse.
I'm Howard Greenberg.
Hi, I'm Nouman Hameed.
Nouman, happy Canada Day. What's on the agenda for today?
Well, lots of news on immigration. One factor that caught my attention is immigration's looking to improve their programming with a $5.1 billion investment.
It's a lot of money to spend. I wonder where it's going to go.
So there's a suggestion. The first area is to modernize their programming, which is, I believe, their internal systems, which they profess are fairly antiquated, and we would say the same.
Data collection, data analysis, AI.
Yes. Hopefully that would deal with some of the backlog of processing. The question is, how will they use that AI? How will it be structured to create efficiency, but also ensure that these decisions are reasonable?
It's going to be trial and error for a bit, a couple more federal court cases and noise, and at some point they'll get it right.
Right. A few other priorities. They talk about ensuring they can reduce the number of temporary residents to 5% of the population, despite the fact that there's massive demand still in Canada. So that will be a challenge. And also trying to attract the best global talent to meet the economic priority. And when they're talking about economic priority, seems like a lot of focus, not necessarily on the metro areas, but regional areas and some of the other municipalities.
So the municipal program, the Francophone program, that's where they're putting the emphasis.
Correct.
It's not about bringing people to Toronto, Montreal, or Vancouver. That takes care of itself. It's about the rest of Canada.
Right. Another change, post-grad work permits. We see there's a new change that will be effective actually November 1st, 2024. They've created a new list of eligible programs in order to get a post-grad work permit if you're not in a degreed program, so a diploma. You have to pick a particular course of study that lines up with our labor market needs.
Well, I think the emphasis is on STEM occupations and occupations that we need in the long term. The point is, we invite these students to apply for work permits in occupations in which we need them long term. So presumably they'll settle through the CEC program, the experience program, and there's no real benefit for Canada to give work permits to individuals who graduate in programs that don't have an economic benefit for Canada in the long term.
Right. So it's very important if you're planning your future, you're looking at Canada, you should be considering where's the best job prospect. Make sure your course of study lines up with one of these eligible programs. And then it could be, like you say, possibly if you're a very well-accomplished CEC or even the provincial programs that have student streams.
You know, there was a time not too long ago where you made your decisions about immigration while you were in the course of a study, trying to figure out which program you might qualify for when the doors were wider. You're going to have to make those decisions at the time you're making an application for your study permit.
Right, well in advance.
Well in advance.
Good segue. The other piece of news, Canada's very keen on Francophones, and we see a study permit pilot for Francophones,
Right.
where expedited processing,
Right.
settlement services to help you get a job,
Right.
and then potentially a faster track to PR because of the benefits of that program. And there's a list of countries that are identified. Again, you need to think ahead as to where you want to study, what the benefits are,
Right.
especially if you're keen on staying in Canada long term.
Let's talk about case law.
Yeah.
Any cases this week to strike your fancy?
Yes, there's one particular case that I read with quite a bit of interest on the startup visa program. This was a situation where an applicant was refused. It was deemed an artificial transaction by the officer. The officer was concerned that the individual didn't have related education, work experience. There was no IP registered in Canada and didn't believe that the business was viable. They had a memorandum of understanding, but not a lot of traction. And counsel in that case argued that, well, those factors are not regulatory requirements. You don't have to have a certain level of education.
Right.
You don't have to have a certain amount of experience.
Right.
Whereas IP referenced and made an argument that the officer effectively created a new threshold outside of the regulations. The judge reviewed everything and said, the officer had the right to look at each of those factors holistically and make a conclusion on whether they felt it was a viable business and basically refused the judicial review procedure in favor of the respondent.
Let's try it another way. It could be a viable business, presents itself as a business that looks real, that looks like it could be implemented. And the immigration officer looked at it and said, when I look at all these factors together, I kind of am concerned that this business could really get off the ground or is intended to get off the ground. And so what this is probably about is a person who wants to get a visa to Canada,
Right.
and he's using a whole discussion about a business opportunity as his vehicle for coming to Canada,
Right.
and I don't buy it.
Correct.
So it strikes me that this case has a lot more meaning than what we just talked about. How many individuals do we know who have been seeking business plans from professional business plan writers who would sit an individual down and write a plan that had a lot of content to it, but the individual really didn't relate to a lot of the aspects in the plan. For example, it really wasn't about the individual taking into consideration his work experience and his history. It was constructing a whole new scenario that he would get a certificate under, or
Right.
she would get a certificate under, and then plug him into that scenario. And I guess the wake-up call from this case is that when you plug somebody into a scenario, you have to be very sure that you can demonstrate that person can do it, is doing it, and will do it.
Right. And you must explain it in detail.
Right.
In this particular case, it seemed like there was some experience, but was it well explained for the benefit of the officer? So additional time and effort has to be made in making those representations.
So I guess the applicant in this does have an argument where the concern is that that there are no regulatory requirements that were not satisfied, right? On the other side of the coin, you got an officer who stands back and says, look, I'm taking a look at this whole thing. From an evidentiary point of view, I'm just not happy.
Right.
I don't believe this is about getting a business going. And that's what the officer is there to do.
And the federal court supported that because we've also debated how far can an officer go
Right.
in looking at the merits of a business, seeing that they're not a business person. But this decision allows the officer to look at the totality and make a reasonable position as long as it's well articulated. And the officer did give an opportunity for the applicant to respond.
So all of this thinking has to come into play when considering making a startup application.
The time of filing.
Before even going and speaking to a designated entity about getting a certificate. In the very early days, the question has to be asked, is this idea a good idea that can be substantiated,
Right.
documented, and delivered? Okay. Any other cases strike your fancy?
That was one that was on my agenda. I think you talked about a couple of interesting cases, one on misrepresentation and the interpretation of the court.
We always see applicants who fail to disclose a prior refusal of an immigration application, saying, "Look, I got confused on the forms. I didn't understand it." This case basically confirms and reaffirms that that's not going to be enough to relieve an applicant of the obligation to make a full disclosure. And the lack of a full disclosure is a misrepresentation and therefore a refusal.
Right.
So that whole thinking about how you complete an application to begin with and make sure it's complete is absolutely critical to the success down the line.
And what seems like a simple omission is a 5-year bar if you're caught under a misrep.
Right.
And very significant difficulty even traveling to other countries and seeking immigration approval. So you can't take that lightly.
Right. I know, man. The Nanda decision is quite interesting because in that case, the officer made an independent inquiry on a permanent resident application as to the information provided by the applicant and found that there were discrepancies between the information provided and what was told to the officer by the applicant's employer. And the officer provided an opportunity to respond to those discrepancies and then formed a view that he found that the information provided by that the discrepancies were enough to call into question the qualifications or the experience provided by the applicant. And so that raises issues as to applicants being very careful as to what they put forward in terms of substantiating their work experience and their qualifications to do a job, and to make sure that those qualifications will hold up under scrutiny.
Right.
Should there be independent inquiry? And this case has a significant importance in the sense that we have seen in other circumstances like SUV that officers have actually called the workplaces of SUV applicants and made inquiries on designated entities to substantiate information. And so it's quite possible that officers will conduct independent investigations to confirm information and determine whether there are any, any issues with the information which go to the credibility of the applicant.
And so in our practice, we often suggest where possible to provide that information up front instead of waiting for an officer to go and look at third-party sources. Provide enough information where it's reasonable on the record. Otherwise, you could have that sort of verification issue come up.
Well, and to be more tangible about it, when we're handling a startup visa application, we'll say to the applicant, what do you think would happen if an officer called your premises and someone answered the phone and the officer asked about your business idea? What would the response be? How prepared would your business be to respond to questions? You have to be ready.
Right.
Thanks for tuning into this week's ImmPulse video. Please don't hesitate to call us or send us a message.
There have been many changes to policy, to rules and interpretation in Canadian immigration. If you have any questions, please feel free to reach out to myself or Howard. We'd be pleased to speak with you. What are your thoughts there?
Well, I think they're going to use the money for AR.
AI? It's Monday. Well, actually, it's Wednesday.
You know,
This is that kind of day. It's a weird
the
day.
headphones could be pressing hard. Okay, fine. Thanks very much for tuning into this week's ImmPulse video. If you have any questions, please don't hesitate to contact us. We'd be pleased to discuss anything with you. We really are lonely.
Lonely is crazy.
Yeah, lonely. Yeah, lonely. Okay.